Good afternoon, everyone. My name is Aysha, and thank you so much for joining us for the Online Minerals to Metals Forum, hosted by the Southern African Institute for Mining and Metallurgy. Just some quick Zoom etiquette. During the discussion, please type your question in the Q&A section in the toolbox at the bottom of your screen. After the presentations, we will have a Q&A session to answer these questions. You can raise your hand at that point and speak directly to the panelist. Please note that this forum is recorded and will be made available to the public. You can remain anonymous by changing your name and leaving your questions in the Q&A. If you have any issues or would like to be added to the mailing list, please send me a private message in the chat and I'll get onto that. So the following session will explore the nature of land security for some of the most vulnerable and historically dispossessed communities in South Africa. How can communities best secure private land ownership, and how can these vehicles, these legal vehicles, be used to further the ideals of land reform and address historical injustices? We are joined by Jacques Jacobs, a doctoral candidate nearing his completion of his thesis, which is entitled Communal Tenure, Security in South Africa: How to Meet the Constitutional Demands of Democratic Authority and Legitimacy. We will explore issues around land ownership in mining communities and how best to protect and develop communal land to benefit the community it supports. I would like now to invite you, Jacques, to turn on your video and present on this very fascinating and important topic. Hi, Jacques.
Yeah, sorry, Zoom is having too many dialog boxes open. Let me just share my screen.
There we go.
Can you see my PowerPoint? Or,
yes, perfect.
Okay, anyway, well, good afternoon, everybody. And thank you to the MTM Forum members and Aysha for inviting me to talk about my research today. My topic, I've been busy with my PhD for a very long time, about 5 or 6 years. And I've been investigating the legal aspects of communal land in South Africa and trying to understand how would one go about in securing land rights. And today I'm going to focus more on the mining communities and the relationship with secure land rights. The overview of my talk is basically going to be, I'm going to look at the historical background, the role of law, and the current legal framework and the land reform framework, and how that affects mining communities. My study, the scope of the study is very broad because communal tenure globally is an interdisciplinary study, and therefore there's thousands of articles of research, and it's a lot of funding also goes into communal tenure and the rights of Aboriginal people. So there's a lot of material. The problem is, due to the nature of the interdisciplinary scope of such research, it's sometimes difficult to make sure that the concepts used and the type of conclusions made from those concepts is actually relevant, and whether that actually makes a difference. So in a sense, the concepts used in my thesis, such as land tenure, communal tenure, property rights, all have a very broad scope, and thus it's difficult to necessarily understand how that would be applicable in specific contexts. Okay, and thus the other problem is, if you look at communal tenure, there's the challenge of there's infinite variation and complexity in local contexts. So we always struggle with having enough information to ensure what we are doing and reforming the law is actually applicable to the communities on the ground. Thus, the the common argument often is that the de jure, so this legal framework, does not reflect the de facto rights, that's the practices on the ground. And because there's they don't correlate, it creates legal uncertainty and often means that the law is unenforceable. The other problem of communal tenure in South Africa is that there's policy vacuum. So there's a lot of policy, but not necessarily enough to create a very good legal regime. So that has been a big problem for the last, well, 30 years in South Africa, that we don't have sufficient legislation to regulate communal land rights. And then, of course, the big question is, if the scope are so wide in these concepts, what should the role of law be? Because many people think that property law, mining law, all of that can only really have a marginal effect on actually creating tenure security. So that is the big problem. And if we then want to use the law, how can we ensure then that that law is effective? Okay, so first I'm going to talk a bit about the historical background. So obviously South Africa has had a long history of racial discrimination, and it obviously started with colonialism. And colonialism, I think one can in general think of as a race for resources. So yes, there was a lot of frontier wars, there was a lot of violence, but colonialism as a project was linked to resource extraction to the benefit of the colonizer. And then they basically claimed land of the countries they colonized, and they created legal systems to create cheap migrant labor systems. So if you think about South Africa, the reserve system was already created in the 18th century. And because of the reserve system, it was the foundation for the migrant labor in the mines in Johannesburg. So the colonizers obviously got access to the resources, access to the best land, and access to cheap labor to extract that. The challenge, though, for colonialists was to create social order in colonies. And in terms of the politics of colonization, at least, those colonizers had to tell the people back home that they're on a civilizing mission. So they can't just pillage the whole world, because that would have been problematic to a lot of the notions of the people in Britain and a lot of the other European countries. Thus, the underlying motivation then for colonialism was to frame it as a civilizing mission, especially as regards to the role of Christian missionaries, but also of the introduction of law. Now, the reason and the way law developed in many colonies, including South Africa, is that the challenge was to maintain social order in these colonies when they didn't really have enough resources to exert control by means of violence. Thus, yes, there were skirmishes, but there wasn't enough soldiers and weapons and resources to wage war for decades. So thus, a lot of the colonialization was actually based on negotiation and settlement. And one of the strategies then was to recognize local legal systems of indigenous or Aboriginal people, and then link that to the territories. So therefore, in a sense, Aboriginal communities was acknowledged as a sovereign, as a nation, but in effect, they didn't really have independence or proper sovereign powers. So globally, then there was three strategies. So the first strategy that colonialists used was what they call first possession, and the Roman, I guess the Roman Dutch law concept involved with that is terra nullius. It came from the Dutch legal scholar Grotius. And what that basically entails is that they said Aboriginal people are not civilized enough to have this concept of ownership and property. And therefore, when they occupied colonial territories, they said the land was vacant, it was terra nullius, and therefore they could establish first possession, and they can establish Western forms of ownership. Other ways that they did it was, especially like in America and Canada, was by treaties and cession. So many of the Commonwealth countries territories were created by means of treaty with Aboriginal peoples, such as the Native Americans, and they received what we call Aboriginal title, which is a legal concept that has been developed for a long time now and is still developing. And then, of course, the other way that they gained political and administrative control was by decentralized or partially delegated administrative areas. And that was especially the case in Africa, which is basically means is that there's a mixture of applicable local laws in specific territories that consign Aboriginal people to a certain territory that and the law that they must use, but the colonial government has administrative and judicial oversight. So it's partially delegated administrative areas. Now, the effect of this was, and this is in the case of most legal systems in Africa, is legal pluralism. Therefore, the effect of recognition of indigenous law created parallel legal systems. However, that doesn't mean that legal system was equal, and in many instances, indigenous legal systems was subordinated to the colonial system, and especially the way that it was to subject indigenous law to what I call morality clauses. Thus, supposedly any law that was in contravention of the morals at the time would not be allowed. For example, example would be, you know, I can't think of any now, but say in some instances, customary marriages with polygyny. But anyway, so there was certain influences from the colonial government. And then what this caused was the indirect modification of indigenous legal systems, and it was used to create social and political control. And the colonialists conceptualized indigenous law concepts to suit their own purposes. And in one sense, they invented customary law. So the customary law that was developed for many years is not necessarily, one could say, a pure or unadulterated version of customary law. It's something that was modified through a lot of political negotiation and sometimes oppression. Okay, so, but the application of parallel legal systems still exists today. And it meant that obviously the distribution of legal entitlements was not equally distributed, because if you are then using a customary law system, it would not have the same concepts such as property. Therefore, because you don't have property in a colonial, in an indigenous law system, you cannot trade it, or you cannot use it, for example, as surety. So therefore, the establishment of these legal systems contributed a lot to a lot of economic and social marginalization, which in a sense was also used to force the idea that of migrant labor and people having to use other forms of income that they couldn't get from the land. So it was used as a mode of oppression. Now, there was a lot of colonial, obviously, legislation, especially in Natal, but for South African land reform systems, the 1913 Native Land Act, which we'll see, I've got a picture there of, was established. And that basically for our land reform program is where sort of the racial segregation discriminatory legislation started. So in terms of the Restitution of Land Rights Act, if you were dispossessed after 1913, then you would be able to claim a restitution if you meet all the conditions of such a claim. So after colonization, there was a lot of racially discriminatory legislation, and a brief overview of that is the Native Lands Act of 1913, the Native Administration Act of 1927, the Black Authorities Act of 1951, which is regarded as the introduction of grand apartheid. And basically all of these legislations created the idea of self-determination of various ethnic and linguistic communities in South Africa, which we know, of course, was not really proper self-determination. It was a form of indirect control. And it was further also developed by the Promotion of Black Self-Government Act, and the Bantu or the Black Homeland Citizen Act. And those legislation that came in the late 50s and the 60s created the South African Development Community Trusts. So that's Bophuthatswana, Transkei, Ciskei, and Venda. So the effect of the introduction of these very complicated legal system was what Mamdani calls decentralized despotism. So in the homelands, basically law was administered by the traditional leaders at the time, and they basically did the dirty work of the apartheid and union government. And therefore, you know, it's all one of the famous sayings about apartheid was obviously divide and rule. So the division was not only geographical, but it was also legal and politically and administratively. So of course, you know, I can't really do justice to, you know, but with this brief overview of the history of racial segregation in South Africa, but the effect of these legislative and the enforcement of it, we are still living with today, and we're still trying to react to it and to correct this injustice. One of the features of all of these legislation, especially the Native Land Act and onwards, was forced removals. So there was large-scale forced removals, and how it worked was basically, if you see the colored areas here is the homelands that was eventually created, but that meant that the common law ownership of the rest of the country, there had to be certain areas that was expropriated to create these homelands. And supposedly it was created around the boundaries of traditional communities in those countries, but in those areas. But it also meant that many Black communities lost claims to their land and their home, and was forcibly removed and basically dumped in other homelands, which obviously gave rise to a lot of other problems. Therefore, if someone is new in a new community, they might not be able to get the same benefits or application of the indigenous law in a new area. And the problem of these large-scale and forced removals was then that a lot of the conflicts that's even visible today in indigenous communities is basically because of the wounds of history and the discord that these forced removals created, and how those people the people that was forcibly removed had to adapt to new customary systems. So in essence, I also show this map because it is really complicated to determine what customary tenure is. And there's a famous saying that says there was probably about 17,000 different regulations that affected property holding in the homelands in Black areas. So it's very complicated in terms of, if you look at history. So there's not something like a universal customary tenure or you know, a specific type of customary tenure linked to a specific traditional community. And that's what makes reform even more difficult, because you then have to use anthropologists and historians to delve into the history to understand the type of claims that was on traditional land and what those claims were of people that was removed. And if you don't understand the law and the anthropology, then it might mean those people won't have a valid claim under the new land reform regime, such as restitution. All right, so yes, as I say, again, very potted history, but in 1994, of course, we then had the Constitution, and obviously it was a negotiated settlement. In one sense, land reform started in 1991 with the then National Party government abolishing most of the racially based measures, which in essence made sense, because that's what you do if you reform land and you want to move away from racial discrimination. But they also threw out a baby with the bathwater, as they say, because those all their records in apartheid, for example, due to the 1951 Black Authorities Act, people's claims to rights were based on what I call permission to occupy permits. That was held at the local magistrates court, and that was used then to trade or transfer property between families or other community members. All of those records, a lot of them are gone now. So there's no a systematic system to understand what the customary land rights is in the former homelands, unless, you know, the permission to occupy certificate survives somehow. But anyway, the 1991 reforms basically abolished PTOs. So that means it doesn't really have any legal validity. But somehow a lot of them have survived, and a lot of those PTOs is used to claim customary rights today in the homeland areas, former homeland areas, of course. So the Constitution in Section 25 demands that a person or community whose tenure of land is legally insecure as a result of partially racially discriminatory laws and practices is extent to either get tenure security or comparable redress. And of course, other sections in Section 25 creates a restitution program that says in the area where common law ownership was in South Africa, thus, shall we say, the European area, or with common law, or where everybody was removed, which is the famous statistics there is normally that 17% of the country was consigned to the black majority in South Africa, while the rest was allowed for European ownership. But so therefore, you know, therefore the land, the Constitution at least embeds a very specific land reform program. And therefore, in 1997, even though most of the land reform provisions is entrenched in Section 25, there was the white paper on land reform. And that created a very elaborate and complicated system. So there was basically three branches of this: the land distribution program, the land restitution program, and the tenure reform program. So land restitution is probably the most known area of the land reform program, because what happened there then was that communities, the government bought the land that communities was dispossessed from, and then restore it to communities. So, and in a way, that program resulted in, you know, the later unhappiness during the past year and maybe previous year about expropriation with compensation. So the question is, if we are doing land restitution and we're returning land, why are we paying market-based prices? Why, you know, so land restitution is very complicated, because in one instance, it's about reconciliation, it's about redress for injustice. On the other hand, the land restitution program is a market-based program, and communities have to apply. Many times, multiple claims are on specific land parcels, so therefore there's a lot of competition. And then there's also the elaborate administrative process that communities must go through to eventually qualify and receive the land. And sometimes a lot of those claims have not been finalized. In 1998, the cutoff date for applications, there was about 90,000 claims. A lot of them were settled by cash compensation, but when the land was returned, they had to use a very specific legal entity, the Communal Property Associations Act. And the idea of this act is basically to create a legal vehicle to create ownership. So therefore, land restitution was on land of the previous, that was capable of ownership, common law ownership. That means that land is registered in the deeds registry office, and it can be bought and sold in terms of common law and law of contract. And therefore you needed a legal entity. And because communities claimed this land, they had to create a special purpose-built act, and that was the Communal Property Associations Act. The underlying idea of the act was that communities would be able to create their own constitution. They could create their own content of their rights, and they can create and manage their rights themselves. Therefore, there was a lot of freedom in how this land could be used. So therefore, it's in a way, the Communal Property Associations Act is a more, I guess, laissez-faire mechanism than, say, sectional titles. So therefore, if you have traditional principles, you can then imposes in the constitution and by democratic vote, and then there would be a committee that will administer land on behalf of the communities. So the CPA Act, the Communal Property Associations Act, is one of the main vehicles for land reform and how land is held. So in most instances then, the land that's returned is vested in communities rather than individuals, and others in other claims, say in urban claims, sometimes individual rights were restored, but in many instances it was settled by means of cash payments. The other important part of the program was land redistribution that dealt with labor tenants and farm workers, such as the extension of Tenure Act. And then, of course, there was a tenure reform program that deals with customary communal land rights. That's the communal land rights that was used in the former homelands. Okay, so very complicated system. A lot of these programs overlap. Therefore, the CPA Act can be used in restitution, but also in land redistribution or even in tenure reform. So application is, and the big thing about that was it's an administrative-based system. So all the applications, everything had to go through government, and they had to process that, and eventually then that had to be confirmed by a court, normally the land claims court. But in essence, the idea of land reform and land restitution in general is there not just to create redress, but also create tools for broadening access to land of the whole country and creating access to natural resources and using the land as the basis for using the resources, having home, having shelter, and hopefully developing or gaining economic advantage out of the land, and thus the ambitions of the scheme is huge, and I think it's definitely a good idea, but to implement it is obviously a lot more difficult. So in general, the property rights relating to communal land, then there's a lot of different ways, but the main four basically in a statute law. So that's the permission to occupy permits that was created by the 1951 Act. There was quit rents that was created in the Eastern Cape, in the Glen Grey area, that was attempt by the Dutch settlers before to individualize property, but it was also adapted in a way to a certain type of communal tenure. And then there's obviously the customary law that is linked to specific traditional communities and ethnicities. And of course, then there's common law, because up to 1907, a lot of Black communities put their money together and bought land, all over South Africa, especially in the northern parts of South Africa, in the Transvaal, as was then now known, so Gauteng and Limpopo and the Northwest and Mpumalanga. And those common law rights, then eventually they were expropriated without compensation and forcibly removed to the homelands. So that's also a source of right. And then, of course, the dispossessed rights that could be anything almost, but those rights create a claim for you in terms of the land reform program. So the communal tenure reform program, there's a lot of legislation involved, and that's one reason it is so complicated. So on this slide, you will see I indicated the KwaZulu-Natal Ingonyama Trust Act. So this act is applicable to especially Natal and the Zulu Kingdom, and there's a graphic of it. I think it's a bit out of date, but it affects more than 4 million people. The Ingonyama Act is interesting because due to the conditions in 1992 to 1993 in Natal, where there was a lot of ethnic violence, there was in a way a backroom deal with the then National Party and the Zulu King, or the Zulu Kingdom, to cede the original traditional areas to the Ingonyama Trust. So this is a trust that was created, and the Zulu King is the trustee of this land, and these days it's administered by the Ingonyama Trust. So it is still, shall we say, customary tenure, but it's used with a different type of legislative control. But if you, but that's one act, so, and that still exists today. But also customary tenure, if you look again, is still applicable in a lot of the old, sorry, let me just delete that. You know, those boundaries still exist as well. So if you can see here, the former homelands, and then in 2015, you can see those areas, those areas are more or less the same. And if you look, for example, at the multiple deprivation index of 2011, you can also see that these are obviously some of the poorest areas in South Africa with the least amount of access to basic services and infrastructure. So the interesting thing, of course, is if we live in a new South Africa and the homeland system has been abolished, and the whole country now is one country, there's not all these separate states, why do we still have these areas? And that's very interesting, of course, because when the original land reform program was designed, they said, we want to reform this area, but we know it's politically very difficult. So, so the thing was, you know, they basically just kicked the can down the road, created temporary legislation of IPOLRA, and yes, so that's what eventually happened. And to this day, then, we don't have proper legislation. We have just the Interim Protection of Informal Land Rights Act. And that is this one. I see I'm running a bit out of time. I've got way too much to say, but I mean, I've been studying for 6 years, you have to understand. So the Interim Protection of Informal Land Rights Act is basically, it's temporary legislation. It says if you occupy an area in the former homelands, you have a basic license to occupy it and have use rights and everything. But it's still based on customary tenure, and you cannot do much with it else. So the basic protection that you have from that is basically is just a license, and to provide consent and compensation if you are deprived of that land rights. And as I say, we don't have any more legislation dealing with that, because the legislative attempts such as the Communal Land Rights Act have been declared unconstitutional. The problem, though, is because IPOLRA has not been developed and there's not new legislation, doesn't mean the law has stopped developing. And therefore, that's where a lot of the problems come in, because we still have traditional leadership in South Africa that's acknowledged by the Constitution. We have legislation that deals with that, and that's where these boundaries come in, because that legislation is based on the 51 Act, and that legalizes those traditional areas and make the law applicable on that, which is controversial for many. So, and then, of course, you know, that's not been reformed, but we have traditional leadership now. And when IPOLRA was created, that wasn't even a concern. So, you know, and then in the rest of South Africa, of course, we had a Communal Property Association, and there's a lot of them. There's almost 2,000 of them, and they're also not very successful. I think about 5% of all of them is compliant, but the law still goes on. It's been found to be constitutional. So those are the two options that you have. Now, how does that relate into mining? Now, the one thing is, in my thesis, then I had to conceptualize what land tenure is. And as I say, it's a very broad context. But the main issues is access and control. Now, if you have access, you can claim benefits, but there must also be control. So the control means someone must protect it, or someone must administer it in a specific way. And because communal tenure is so difficult, if you see, like, for example, here, the type of rights that you can have, and it's so contextually unique, how would you then create legislation for that? And that's one reason we don't have it. But the big thing then is, if you look at freehold and common ownership, that obviously vests in a person or a company or anything. It's registered in a deeds registry office, so you gain access to it by buying it, or, you know, or inheriting it. And then you have a lot more control, because the only control that the control over you basically then is all the municipal laws and property, like environmental laws and those things. But if you look at communal property, then the state is the trustee of that, so nobody owns it itself. And then how do you control that in terms of the Constitution is where the challenge then is. And if it's not successful, then it's open access. And the problem, of course, is that the state must administer all of these things because they still are the trustee of the land. And if you look at here, for example, there's a lot of property that's still in the state, and that includes more than 70 million hectares of former homelands. So that's all in control of the government. The minister is trustee of the land, and if anything happens on it, the minister or the person they delegate to must give consent. So that means, if you have land rights, you cannot do much with it. You cannot sell it, you cannot be registered, you cannot get a loan. So that's where the problem then comes in with mining, because with mining, you have these areas that was never really developed and it wasn't really mined. But South Africa is a very mineral rich country. So the problem then is, how do you exploit that right if there's no ownership? And who's going to benefit from that? And therefore, the whole thing is then that you get a mineral and petroleum resources development framework. And that framework basically created state custodianship. So up to 2004, if you have mineral rights, it was part of the content of your ownership entitlements. So you could sell that as a limited real right to someone else. But after 2004, the state was custodian, and then the state created an administrative regime to provide access to someone. Now, in many instances, mining is expensive. That means licensees must apply, and they can apply on anybody's property as long as they meet all the requirements. And in effect, what happens then is that landowners, even under common law, but also traditional communities, cannot really say no to this mining. So, and the act is very vague in that sense, because it only creates dispute resolution mechanisms. It, for example, also don't say if someone mines on your land that you actually might benefit from that specific minerals. The only way you can benefit from it is by surface leases, or the fact that they're using your land for roads or other infrastructure. So that is the big problem then, that if you were in a customary community, you didn't have access to the mineral rights in the first place because you couldn't have ownership. But now you're also not necessarily going to be able to benefit from those minerals, but you can also be affected by it, because we know mining and prospecting, all of that can create a huge toll on the environment. There can be a lot of expensive issues, cost involving in mining. So therefore, the Mineral and Petroleum Development Legal Framework creates an administrative process to create applications and mediate disputes and eventually awarding licenses. And therefore, in a sense, let me just see here. The possible benefits that communities might get into mining is a lot more complicated than just saying you have a property right, because the way the MPRDA is set up is that there must be broad-based black economic empowerment. So somehow the community must benefit. There's the mining charter, there's the social and labor plans that supposedly should help with creating infrastructure, housing, and services for communities affected by mining, and sometimes they might get compensation, or they get resettled, or they can get compensation for deprivation of surface rights, or compensation of expropriation and compensation from surface lease agreements. But if you follow the news, the most famous one probably is Zolobeni, is that this whole process in a way is undermined, because not that is true in law, but when mining companies have to deal with communities that are maybe 500,000 people strong, they are probably not going to engage with that communities on the ground. They're probably going to engage with a representative such as the traditional leader. And that's where the problem then comes in, because in one sense, there's historical accusations or claims that those traditional leaders basically inherited their position from being set up in apartheid, a decentralized despotism. Other arguments is that these traditional leaders do not engage, or engage in their own interests rather than in communities. For example, they can get the directorship or other benefits in shareholding, and that communities also don't get some of those benefits. And of course, the worst thing is, of course, when they mine and there is blasting and everything, and they have not consented to that, they cannot claim compensation. So therefore, if you look at the Interim Protection of Informal Land Rights Act, it says the whole community or the majority of the community must consent to any of those deprivations. And that has been the development in South African law then to say, yes, the Constitution allow communities in terms of the Interim Protection of Informal Land Rights Act to also provide consent for mining activities. So that has been a gray area because, and the other problem is, of course, the IPORA is applicable to 40 million people, but nobody really knows how much, what the scope of the application of this is. And therefore, then, as well as we can benefit from this. And therefore, the law has sort of developed in the void. Because we don't have communal tenure property, we have to go on with this interim act, and that is where the development now stands. So the law, in a sense, in terms of the rights of mining applicants with ownership or even communities, basically are on the same footing. Perhaps one can argue that communities have more protection because they have to consent in a certain way. But I mean, the problem as well is that most communities don't have access to maybe to extensively litigate. So therefore someone else must take up their cause. And because we don't have proper legislation that governs proprietary rights, that means you have to go to the court the whole time. So the main challenge then is to, for at least for mining, is to create the consent and distribute the benefits in an even way. Now, in the last 2 or 3 years, there was cases in the Constitutional Court, the Maledo case, and in the Baleni case, that's also on appeal now, that basically established the fact that communities can say no. And the biggest thing that needs to be developed now is what the level of that consent is. So how can you give consent, and what type of rights do you give consent to be deprived of? So that's a challenge of how the law should be developed, but because we don't have proper legislation, it all sort of, it's like water, it flows everywhere. So, and while the law and the courts protect most communities very well in terms of this type of legislative framework, in reality, a lot of communities will probably lose their land or have to suffer through a lot of environmental degradation and suffering. So because there is not proper law, and communities often cannot use IPORA, so they must use a lot of alternative strategies. And most of the strategies in terms of communal property associations and traditional communities is just to be able to participate in decisions or even in consent decisions. And that's where the law is also developing quite a lot. The basis of that is customary law. So that's context specific to every village in the country. And therefore the court must all the time determine what kind of law that is. That means, make litigation also very expensive. But if you look at communal property associations that's been around for 30 years, you know, those disputes just doesn't stop, you know. In a lot of those communities which, you know, must use the resources to build themselves a future, spend it in litigation because of factional battles and conflict. Because if you're in control of that property, you can benefit from it, or you can decide who can benefit. So the safety valve for that, supposedly in communal property associations, is the administrative framework of the state to look after these communities, and that's the same with IPORA. But in the end, if you look at land reform in general, or even the role of land reform in mining, is that everything basically depends on the state providing protection. And that is basically the weakness then of the whole land reform framework, as well as the developmental framework of South Africa, and also the property law framework, because the state must provide a lot of administrative measures to ensure that these communities' rights are protected. So because these are specific rights, they are normally protected administratively rather than legally. So in ownership, if you want to protect your rights, you need to go to court and use a Ravendy here. But with a lot of communal property associations, they have to use administrative state frameworks. That means there's like eternal conflict dispute resolution measures. And that's where the problem comes in. The state, especially the Department of Rural Development and Land Reform, do not have adequate capacity to deal with these things at scale. And if you then think they need to develop legislation to create tenure security, say for communal property rights, how would you do that? Because the one thing you will need to do is you'll need to decide who lives in each property, and therefore you must have a record for that. So even if you create new legislation, you know, it's a steep demand. And if you, for example, you know, and that's a problem. So the state's obligations is almost too much, and the problem then is the courts hold the state obviously accountable in terms of administrative law and Section 33 of the Constitution. But it also means, again, you have to go to court. And what happens then, because of this administrative process, the courts will often say to you, well, you have to exhaust internal remedies before you can go to court. And if you do that, and nobody keeps by the rules, so as, for example, someone starts mining before they're supposed to, you might already have a lot of damages and you might actually lose your land. And what makes this even more scarier is if you look at the Department of Rural Development and Land Reform's budget, you know, it's never really been at all adequate at all to create proper land reform. And then if you start thinking about mining and all of that, you know, and how that should be protected, there's just not enough, you know, resources. And in a sense, to solve this problem means political will by the government that is in power at the time. And that also means they have to provide capacity, adequate systems, and adequate money. So that is the biggest questions. Whether communities are protected in terms of courts, yes, they are. But in terms of the administrative system, no. And it probably means those type of battles is going to be waged in courts. So in terms of the future, what we're all waiting for is communal tenure legislation to formalize the rights in the former homeland. So there's a communal land tenure bill now. It's been on the books since 2014, and the newest Minister of Rural Development and Land Reform has said, no, they're going to shelve that bill and start again. Even if that bill goes through the process, it's more than likely to end up in constitutional court, and that might mean legislation won't be forthcoming up to 10, 15 years. So then, of course, the other thing is, you know, there's the living customary law. So if you claim customary claims, that changes the whole time. And perhaps the only way then communities would be able to force the state to create tenure security by other means and legislation is probably to sue them in a constitutional court on the basis of socioeconomic rights. And the idea of that argument would be then, if you remember the New Clicks case, where government was compelled to provide a system of ARVs to a broader part of the population. That would be the same type of litigation that would probably create a bit more tenure security. But because of the administrative system and the weakness of it, it probably, unfortunately, is not provided. Okay, sorry for going over time.
No, please don't apologize. That was fantastic.
Go on.
No, I mean, I'm just glad that we got so much information.
Yeah, well,
and I wish we had more time.
Yeah, I mean, theoretically, if you then start looking at global research and policy, you know, it's, you know, a lot of what South Africa received funding for, say, from the World Bank and IMF and those people, is to create property rights and legislation for property rights. But, you know, how and what those rights should be, you know, that's difficult to implement.
Yeah, so removed from the grassroots context. We have quite a couple of questions, so I think we should get started with those. The first question is, in your studies, what have you defined as the mining communities and why that definition?
Okay, so yeah. Okay, so
I just want to read the last little bit because I think it adds to the element. Can you hear me?
Yes. Okay, so communities, in terms of my research, communities obviously is defined in terms of the land reform and the land claims process. So therefore, communities is defined in terms of the Restitution of Land Rights Act as the descendants of the claimants that lost the land. And then they must be defined as a cohesive enough community to qualify for the land claim, but they also can create a new community as a communal property association. So communal property associations and the definitions of restitution is a legally defined thing. In terms of customary law, communities is defined in terms of the customary law, legislation, and the type of ethnicity of the community. Therefore, that would be the definition. In general, my studies don't look at ideas of the broader mining community. That's, for example, the people that lives around a mine, or as laborers, or is part of the other parts of the system. But most of these, the people that I study, they live in the vicinity of mines, and they are affected, and they obviously also sometimes are laborers or affected by other ideas. But in terms of my studies, the definition of communities are very set, which is in a sense one of the big problems, because if the communities is so big and there's overlapping claims, how do you then decide someone is part of, say, a specific traditional community, but when do you decide when they're a citizen and they have rights of free association, and why should they then be limited by their own customary law? So yes.
So are you hoping for a definition from the bill?
There's a lot of definitions in NEMA, the National Environmental Management Act. There's definitions in the MPRDA. There's a lot of definitions in the restitution. The problem though is because it's law, it creates a legal administrative personality, a unit, which is basically, the problem is minorities get swept up. And that's why a lot of the litigation strategies then is to say, well, if I'm part of this community, how can I participate? How are you not going to sideline me? So that's why a lot of litigation is about that. And for example, if people wrote ideas of consent. So, and that is normally considered internal to the community and not related to, say, licenses or people that buy land, you know, outsiders that buy the land. So definition of community, massive problem. I think it's unresolvable because of the complexity of in general of these communities. I mean, the idea of Zolobeni, that probably everybody knows about that one, is Zolobeni's fight is basically a few villages that band together, but other villages have interests in the mining application and pursuing mining, while these communities saying we don't want to mine, so why aren't you not listening to us? And that's basically what a lot of the fights are about.
I have another question from Biolongo. He thanks you for a very rich presentation. Oh, now it's disappeared. There we go. We know, as you're sharing it, that there has been discriminatory laws in apartheid South Africa. How do we ensure that we do not have such laws today? How do we prevent reverse racism or xenophobic discriminations in the new dispensation?
Well, yeah, thank you. That's a very interesting question. I think if you're interested in law, and especially constitutional law, that basically goes to the heart of the type of society we must create. So how do we avoid it? Well, the one thing is we abolish those old racial legislation, which we've done in most instances. So that's one way. So on the books, at least, it doesn't exist. The problem, of course, is all the systemic manifestations of racism. So, you know, and those things are more complicated, and especially it's not necessarily just a racial thing, but it's also within communities that compete with each other. In one of the bases of, I think, customary tenure and customary property rights is the idea that it's based on negotiation and conflict. Conflict is basically part of exercising your rights and how you mediate that with others. So the idea is we need to create safety valves for that. And I mean, the biggest issue perhaps in terms of communal land rights is, of course, women's rights and equality rights. And you know, if you fight or you argue these things in a constitutional court, your first basis would be my equality, dignity, and freedom is infringed. And at least in South Africa, we have a constitution that allows us the basis to fight that. In terms of legislation, I mean, it could be superstructures. You know, systemic racism is something we'll have to deal with probably for the next 100 years.
So we've got another question from Matthew Banda. How do mining communities deal with people they displace to make room for operations? Do they offer resettlement or compensation?
Okay, so in terms of the Mineral and Petroleum Development Resources Act, most of the duties of engaging and consulting communities is put on the mining company or the applicant for prospecting rights. So it's on them, the onus is to ensure they've engaged with everybody. And then, of course, there's a massive administrative requirements that you have to meet in terms of environmental management, in terms of social management, in terms of municipalities. So a broad array of government actors is involved, supposedly, and communities on paper is supposed to be consulted. So if you want to mine somewhere, someone must make way for that. Yes, normally that will mean there would be some type of compensation, and normally that, you know, there's packages of those things that you can almost say. There's a new white paper out on resettlement and compensation of communities, but I mean, obviously that's up to negotiations. In law, we don't really have set prescriptions of how that should work. Although in the MPRDA, the safety valve is if there's deadlock and conflict cannot be resolved, then the government can expropriate the land and then supposedly provide compensation for communities. Yeah.
So a further question from Matthew: do mining companies offer corporate social responsibility programs to improve livelihoods of communities living in and around the?
Well, yes, they are mandated by law to establish corporate social responsibility programs. In terms of law, for example, they must commit to developing social and labor environment. That means they have to provide infrastructure, build schools, build hospitals, provide training for possible labor. You know, that's all mandated by law. In general, corporate social responsibility then is not only about, say, what a company says in their statutes or in their marketing. There's a lot of like legal provisions, including, of course, rehabilitation of environmental rights. Whether that is actually successfully implemented or done, well, we know, for example, from Marikana, where Lonmin promised to build a lot of housing and never delivered, what the consequences of that will be. And the thing is, you know, we don't really know or hear of many of successful projects of that, and that's probably one problem. The government, in a sense, holds the card that says if you don't do it, you're going to lose your mining license, but it's never happened. So that's a big problem.
So we have a question here from Richard McLean. Have you looked at the possibility of customary law land ownership without recourse to common law concepts of property, in light of the fact that it was trying to fit customary law into common law framework that led to many of the difficulties that we have today?
Yes. No, I agree with you. Now, I've looked at, the thing is, yeah, I've looked at those positions. Now, the challenge is in terms of the Constitution, customary law is on the same level as common law, as, you know, a source of law. And in a way, the customary law, just as common law, must be in line with the Constitution. Therefore, you know, for example, you cannot discriminate on the basis of sex, which for example, in many years, Black women was regarded as minors of either their husbands or their fathers. So therefore, we have certain legislation that specifically regulate customary law, while still allowing for all of that freedom. The communal property associations is a good example of how we're trying to fit customary law in a common law system. Customary law as such is tricky because the type of law that's protected in South Africa, at least by the court, interpreted is living customary law. So that means if you claim a customary claim, it depends on your local, intermediate, and present context. And if you want to, you know, it makes sense then, for example, in the homelands to say, you're not going to be able to survey land, you're probably not going to be able to resolve a lot of conflicts. So something like the Interim Protection of Land Rights Act is a way to regulate it by saying, okay, you have occupancy rights, you must be protected in a certain way, and then we can develop that. But the problem then is customary law can change all the time. There's no way that any government can just broadly regulate customary tenure because it's so very and complex and dynamic. So one way people say how you must do it is by decentralization, by saying if a community wants to determine their rights in a certain way, they must do it themselves, and they must create their own administrative systems that then governments provide, acknowledge, but also provide legal consequences for. So if you can protect it in a local context, your protection comes from the community. But if there's a certain way of, say, for example, recording the land rights, that creates broader protection if your rights are threatened.
So we've got a question from Anonymous. Using your term custodianship, over time, government has separated mineral rights from land ownership. Water rights was separated from land ownership. Even a thing like biodiversity is separated from land ownership and is now a national asset and no longer the landowner's property. My question is then, how is this manifested on communal land? Has these rights, minerals, water, biodiversity in communal areas successfully been separated and reinstated by the state?
Okay.
Retained by the state, sorry.
So in terms of the overall legislative regime, the separation, or as we can talk about custodianship, is applicable all over South Africa. Those, for example, water rights, mineral rights, all of those things are anyway separated. The problem, however, is with communal areas, especially in the homelands, is that the state, the land is under trusteeship of the state. So the final determination of how those rights should be used is still made by a minister, even though it's on behalf and in the interest of the holders. So in a way, the water rights and all of those things have been separated. Whether it's successfully applicable or applied and implemented in those areas is there's a lot of case studies says that doesn't happen, often doesn't happen successfully. For example, we know, for example, water boards all over South Africa. There's a lot of capacity and conflict and problems with just regulating water and supplying water. So a lot of those rights are applicable on communal land, probably because of the custodianship model. Most of the occupants of communal land probably, are deprived of those rights.
Okay. So we've got two questions from Richard, but because I've already asked a question from Richard, I think that I'll get you guys in contact. And you can speak to that. But then, so there's one more question, just because of, in the interest of time. Cledwin, from Cledwin. How is financial compensation for land calculated, since land can change purpose with time and gain potentially substantial value in cases where financial compensation is given and later on the previous owners realize that they got way less than the full potential of the land? Is there an instrument for redress?
Okay, so in terms of financial compensation, in terms of, say, mineral deprivation, so if you are deprived from your land rights because of a license to mining, then that compensation would be for the damages you suffer. So if they build a road across your property, they must determine that. In terms of broader property valuation, there's the Office of the Valuer General that was created a few years ago that specifically determine a lot of the compensation, especially in terms of expropriation and valuation of land reform properties. In terms of valuation of communal land, that's a lot of times difficult to determine because those properties are not, they don't have the same range or scope of rights in, say, normal ownership have. So how you determine the value of a customary law right is probably very subjective. In terms of expropriation and compensation in general, yes, most of the times you will get a lot less than actual property is worth, but that is because the application of compensation in terms of the courts is very conservative, and the idea is you can't put too much of a burden on the state. In some instances, though, some communities, some people do get very well compensated, and the best example of that is the restitution case of the Mala Mala Game Reserve, the Mashashemi community. where, you know, the government eventually paid the owners of that game reserve R1 billion. That was one of the catalysts for the idea of expropriation without compensation, because that was completely ridiculous. So the problem then is, in restitution at least, government has been willing to pay market-related prices, while there's nothing in law that prohibits them from paying a lot less or expropriating. So yes, a lot of times you will anyway not get a lot out, but it's because of the conservative application by causal value. Okay.
Yeah, perfect. And thank you so much, Jacques. There are a few other questions, but because we've run over time, I'm going to send them to you, get the answers, and distribute it amongst the attendees, so that there is.
I see this one from Richard. Perhaps I can just quickly say, free prior informed consent. Yes, it's the basic standard in international law. It's although the Baleni case discussed it, it's not settled in our law yet. A lot of people try and equate it with the type of consent requirements in IPILRA, but I don't think it's the same. I think free prior informed consent goes a lot broader in scope. I think it is ideal to go for, but then again, if you start, you know, in a way, it's the same problem as with IPILRA of consent. Is you still need procedural fairness, and that means you need procedural fairness from the state in the first place. And if you look at Baleni and Maledi and those things, that didn't happen at all during those processes. So at least free prior FPIC can give you the procedural, you know, action to actually claim your rights or compensation.
So I guess if you want just to quickly answer Aubrey's question, how do South Africa's land laws and protection in mining fit within the larger processes like the Africa mining vision?
Well, I have to admit, I don't know much about African mining vision, but I know from government publications that there is a lot of commitments to that. And in terms of the relationships of Africa, the continent, in terms of international relationship, the African mining vision does pop up. I think if you just talk in general and talk about policy and those things, I think a lot of it, in South Africa at least, links up with it, because we have a good constitution, because a lot of our legislation has good tools for you to enforce or claim damages. So in that sense, I think we're not doing too badly. Where we struggle is a lot of times with artisanal mining. There's not really proper regulation for that, if you ask me. But the other problem, of course, is there's so many people that don't have access to law, access to information, access to decisions. So in that sense, we fall short at application and implementation. But the land laws itself is not too bad. We would like to have proper communal tenure legislation at least, so it can create more certainty of what people on communal land could do with those rights. And in a sense, that's a political question, because you know, you will have to decide what you want to do with the rights. Since the late 80s, the biggest concern and most activists' concern is, if you upgrade communal tenure to normal common law ownership, or is that holder and that community going to be able to hold on to the land and not lose it, you know, for not very good compensation, or because of bad debts? Because that's what happens with communal property association. A lot of those people lose that land that they reclaimed and was restituted because of debts, mismanagement.
Sure. Definitely steps into kind of a
yeah. It's crazy. As wide as you want, you know, just like land is a rubric where a lot of societies conflicts is played out. So if you want to do a thesis about it, the secret is delimitation. So and that's difficult then, because if you think, oh, I'm not dealing with this because it's not property law, you can then see later on how systemically it is a massive problem. So there's a lot of issues. And you know, I've got, you know, it's difficult to, you know, everybody thought in the 90s that a lot of these administrative things should be on the state, because in apartheid years, the state was the ones that were oppressing everybody, you know. So in the new constitutional regime, if we have a state that can service its citizens, you know, it seems the most plausible way to do it, because we can use the resources from the state and taxpayers then to ensure, I guess, smaller instances of justice and redress, but the scope and the challenge of it is massive. I mean, 14, 16 million people, and then we're not talking about the general unemployment, the other lack of resources we don't have. So, no.
Just one slice of the pie, I guess.
Uh,
Yeah, I have to unfortunately close the session. Thank you so much, Jacques, for stepping in and providing such an incredibly in-depth analysis of communal land and ownership within South Africa. I really appreciated the historical consciousness that you brought to that as well.
Yes, I didn't even get halfway through my presentation, so I guess you will put that one up, and I will just make sure my references are properly done, and then that will also be available. Will provide more context for a lot what I've said. Yeah.
I'll definitely send through the PowerPoint to everyone, and we'll have a recording up as well soon, hopefully by the end of next week, that I can send through as well.
Okay. Thank you for all the questions, and thank you for listening. And thanks, Aysha, for inviting me.
Of course. Thank you so much to everyone that attended, and participation was great. Thank you. Have a lovely day further, everyone.
Stay safe.